application is a matter of the K on the application of comments and the Judicial Appointments Commission.
Yes, good morning, Mr. Vaughan. Can I just say a few things before we start?
My lord, yes.
We've got a half day listed for this application, and the court has considered the papers pretty carefully. And I just wanted to highlight before we began what we will and what we will not be considering today. And the first thing to say is that Mr. Justice Swift noted at paragraph 8 of his judgment that each ground raised an in-principle challenge, and he said that the pleaded case did not invite adjudication on whether the evidence relevant to the working and communicating with others criterion was insufficient, was per se irrational, rested on some material factual error, or was otherwise unlawful. But he said instead that the case rested only on the in-principle approach to Regulation 30. And this is what he said. In substance, therefore, what is in issue is the process used by the JAC when considering the claimant's applications, right? And so he said that the grounds were therefore, quote, self-contained legal issues, right? Now, my first question, which is going to have to be answered this morning, is whether that remains the position. Okay? You don't have to answer it now, but you'll be thinking about that. That feeds into the question which the court asked in correspondence last week on the 10th of June, when we asked you, Mr. Vaughan, the appellant, whether she still sought, either primarily or in the alternative, each of the forms of relief pleaded in the claim form, that's at page 141 of the core bundle, and if not, which heads of relief were pursued by way of this application. Now, I have in mind the document headed Amended Details of the Remedy Sought.
Yes.
And that document is found at page 141 in, I think, the hard copy bundle, 143 to 144 of the soft copy. And it seeks 11 heads of relief now, one by amendment, of which, so far as I can see, but I invite any submissions you want to make, only numbers 3, 5, 6, 7, 8, and 11 are at first sight what the judge might have referred to as in-principle heads of relief, and the others relate specifically to the case of the appellant. So that's really my first question, and we need an answer to that. The second question, really, I think I've made two so far. The third one is that we wanted to save time a bit by indicating our current inclination, having read the papers. We remain entirely open to be persuaded by either side, and we're very conscious of how difficult and important this case is, and we're particularly conscious of the importance of statutory consultation in the judicial appointments process. And I mean, all of us, of course, have been involved in that process. I don't think we need to declare an interest, but we obviously have participated in it right up till today. But we wanted to indicate our current inclination, which is that on the questions of, broadly put, fairness, Article 8 and Regulation 30, we are at the moment inclined to give permission for judicial review for the application to be made. On the question of the amendment in Article 14, we're disinclined to allow that at the moment. We don't see it adds anything really, but you can tell us we're wrong. And fourthly, we're of course going to hear the argument today, but we want to know specifically, as we said in our document, that if the court decides to grant permission to apply for judicial review, whether it should exercise its power under CPR Part 52.8 Subrule 6 to order the applications should be retained here in the Court of Appeal, and what directions either party will be seeking as to any further evidence, timetabling, or any other matter. So that's the programme. We've got half a day, but we're not going to be rigorous about that. If it had to go over to this afternoon, it will go over to this afternoon. As I say, we regard this as a matter of great significance and importance to the judicial appointments process. Mr. Vaughan, sorry to be so.
My Lord, I'm very, very grateful for those questions, which I will certainly answer in the course of my submissions.
And you can, I mean, I don't want to be rude about it, but having heard what I've said, you will be conscious that it really is incumbent on you to leave Sir James a good amount of time to say what he has to say.
My Lord, yes. Well, I will try to answer those questions directly first, and then come to what I was going to say by elaborating, I suppose,
yes,
on what those answers are. I have noted Mr. Justice Swift's point about the in-principle challenge. The reason why no evidential sufficiency, reasonableness type arguments have not been made about the working with others conclusion is because Judge Thomas does not know the basis for that decision. She obviously knows part of it, and we know that from the pre-action protocol response and the respondent's pleadings. But this is a case in which she does not have the basis for the decision, and so it is not open to her to argue that there was insufficient evidence, because she doesn't know what that evidence was. And that is why the case was brought as it was. Having said that, the way that I have sought to amend the case in this court has sought to make arguments about the way in which Article 8 precludes the decision-making process on the facts of this case, because inevitably the way that the procedural requirements of Article 8, which is the first aspect of the Article 8 ground that I've raised, inevitably requires a look at the entire decision-making process and the public interests underlying that process. And so, while
I'm not sure I really understand that. Can you say it again, perhaps?
Well, the Article 8 ground has two elements. The first is that the decision-making violated the procedural obligations in Article 8. The second element is that it was not a justified interference and was not proportionate. Now, in relation to the procedural obligations argument, that requires looking at whether the appellant had sufficient involvement in the process to safeguard respect for her Article 8.1 rights. Now, that argument, which is made in relation to the decision-making in her case, has to look both at the system and at what happened in her own case. And so what I was going to do under my Article 8 submissions was to address distinctly the procedural requirements limb, as is set out in the first part of my skeleton argument on Article 8, and the proportionality limb. Now, those arguments are not at the level of the system, but they do involve considerations of systemic matters, like particularly public interests. And there's a lot of my skeleton that is focused on the other public interests that attach, that are engaged in this.
Mr. Vaughan, we're not going to get in this morning to the detail of your grounds, and we're not going to redraft them for you, or anything else. All we want to know, really, simply, is do you seek to proceed with the 11 heads of relief in your amended grounds, to which I take from what you've been saying, the answer is yes.
Not all of them, and I'll just reacting to what my lord has said.
Yes.
Going through those heads of relief, we will be seeking an order quashing the decision of the Selection and Character Committee, and an order that the decision be reconsidered. That would follow from.
Sorry, reconsidered is still one. Yes.
So that would require amendment. So it read that the order quashing the decision of the 4th of April, and an order that the decision be reconsidered. That would flow from the procedural obligations argument. If it's accepted.
Yeah, just to spell it out, I'm sure everyone else is there. So you're taking out and that the claimant be recommended for the office.
Yes. Of circuit judge, or that, and the last line, and the words without reference to the statutory consultation material.
Your junior could possibly put in a document which would help me, and I expect Sir James, amend it as you would like to amend it. I assume only by deletion.
My lord, yes, I think it would require after the 4th of April 22 and an order, but yes. We're quite happy to proceed.
Don't worry about that. Clarity is what we're looking for, but
Yeah.
we are, you can't go on amending judicial review applications indefinitely.
My lord, yes.
Okay, so
the amendment that I've just indicated for paragraph 1 would flow from an acceptance that the decision making violated the procedural obligations of Article 8. The second paragraph might read as this.
Would it only flow from Article 8?
I'm sorry, my lord.
Would it only flow from putting the case under Article 8?
And the unfairness ground, and if the regulations are held to be ultra vires to any degree, because it would be a decision that was made under ultra vires regulations, and so the decision would itself.
yes, I mean you ought to know that certainly our thinking is that the unfairness ground and the very difficult question of whether the statutory obligation mandates complete confidentiality, what should be done in a such situation of this very difficult kind, seems to us the really problematic issue.
If I lose on the Regulation 30 argument.
Well, yes.
Anyway.
I mean, I put Regulation 30 well down the list of importance. I mean, obviously, it is what it is, but the real question is, how do you deal with this knotty question when it creates unfairness of the kind that the judge acknowledged?
Yes.
And it's not easy, because once you take your finger out of the dike, the hole in the dike, forgive me, Sir James will be saying that it falls down and the process cannot be sustained, and that's the purpose of the section. So, I mean, I just say that, but I mean, you carry on. I mean, I think what I wanted. Let's go on. Two.
Yeah,
what about
yes,
two?
I mean, yes. So 2 would be strike out alternatively, because and I would. It seems to me that it would say that before the decision is reconsidered, the claimant be afforded an opportunity to see and rebut the previously unseen statutory material on which the Selection Character Committee relied, or see a gist of it as approved by the court.
Okay, well, I'm not going to write that down.
No. Well, we can. Yes, we will, of course.
Anyway,
I'm
you
just doing
continue
this
with
already on my feet, but I will certainly ensure that is provided, of course.
Okay, 3.
3 would flow from an acceptance of the Regulation 30 argument, so that would remain.
4.
3, Roman 3 and Roman 4 would flow from the unreasonableness submissions. 5 and 6 can be struck out. Paragraph 5 would remain. Paragraph 6.
No, sorry, don't take it too fast.
Sorry, 5 and 6 under 4 would come out. I misunderstood.
Yes, 5 and 6, Roman 5 and Roman 6 would come out.
In fact, the numbering is rather eccentric because.
It is.
Yes, I see.
And then
Automatic numbering.
numeral 5, by reason of the manner in which the defendant seeks statutory consultation, would remain, because that's the Article 8 point. 6 would, paragraph numeral 6 would come out. Articles 13 and 6.
where it comes out.
Yes.
Sorry, I've got lost now.
So the final paragraph is about, it refers to our
Final paragraph of what?
Of, well, sorry, on my version it reads a declaration that
Oh,
the
I see.
system
That's number
operated-
6. Yeah.
Sorry, numerals, yes, numeral 6.
Okay.
System operated by defendants have breached the claims 13 and 6 rights.
Comes out 6.
Comes out.
7.
7 would remain with amendment. I would need to think about this, but ultimately we are not saying the entire, if the regulation 30 argument is accepted, we're not saying that the entire system is ultra vires. But a form of paragraph 7 would need to remain.
Okay, I mean, I think you do have to be a bit realistic about the ability just to amend at will everything. There's going to come a time when you're going to have to nail your colours to the mast. But anyway.
My lord, yes, I did want to see how the wind was blowing, so to speak, before I pinned my colours to the
I'm not
mast.
sure that's inappropriate. I'm not sure
Why
that's
you were asked in advance, tell us what you're now seeking.
My lord, yes, and I'm seeking to do that, and I apologise that that wasn't done.
Yes, well, I mean, just bear in mind that if you do try and amend substantively, that I suspect is likely to be objected to on the grounds that you've had a long time to put this case together.
My lord,
Okay, 8.
8 would come out.
8 comes out. Yeah.
And no further amendment.
And you want 11.
I want 11 in,
What I've
yes.
said. Okay. Why, I mean, cutting to the chase here, 11, why does 11 really add anything? Because of the gist point.
Well, if the amendment to paragraph 1 that I've sketched out is made,
Yes.
then it would not.
Right. So 11 can come out if gist goes into 1.
Or just was going to go to 2, I think. Isn't it?
Yes. Or a gist of it approved by the court would be one way
Okay.
of putting it.
What do
Yeah,
you say
paragraph 2.
procedurally, Mr. Vaughan, about what we should do if we do give leave?
If the court gives leave, what we ask for in the notice of appeal is a remittal to the High Court. I hear what your Lordship says about the nature of the case and the importance of the issues raised. I would say that Judge Thomas's position is that we're in the court's hands about that. The court has obviously made an effort to look at this very carefully, and the Constitution today underlines that, and so were the court minded to retain it.
But let me tell you the reason.
Yes.
We don't normally retain things if there's got to be a proper trial full of evidence and
Yes.
difficulty. If, on the other hand, the evidence is confined, as it is in this case at the moment, and nobody is asking to put in reams of further evidence on the points that permission is granted for, then we might retain it. And our present inclination is to do so. But we don't want to retain it and then find that you all come back in 2 weeks' time and say, we've just thought about it again. And we now think that we want to file reams of evidence and have 4 pre-trial hearings and weeks of dispute. So that's the
certainly from Judge Thomas's perspective. I don't imagine that we would have anything else to add. It seems to me, given that any evidence would likely be about.
So it's a
justification.
It's a question for the JAC, really.
My lord,
Do they want to add anything?
My lord, yes.
Yeah. Okay. Good.
Yes, and so if the court granted permission to appeal and permission to apply for judicial review, which my submission would flow from a grant of permission to appeal, it would simply be a question of giving the respondent an opportunity to put in anything else they saw fit to rely upon. Sorry, after the appellant has made any further amendments to reflect our discussion just now, the respondent have an opportunity to put in anything else evidentially and their statement of the case, and then the matter proceed by way of exchange of skeletons.
I mean, there's one other possibility that Sir James may raise, which is that we don't actually grant permission, but we order a rolled-up hearing of the permission and the substantive matters.
But I don't have any objection to that.
You don't mind? Okay.
No.
All right. I mean, I'm inclined to say that we've had the benefit of your very helpful written submissions. We now know what you say about belief. Is there anything else you want to say? Obviously, you'll get a chance to reply when you've heard
Yes.
things.
It may be then that I reserve saying anything else until I've heard from Sir James. What I would say is that I put in 2 authorities yesterday. I apologise for the timing of that, but they are on the question of privacy. In the skeleton, the engagement of Article 8 issue is focused on the sort of consequences of the decision, so reputation, psychological integrity, etc. And privacy is listed, and those factors are dealt with reference to the Denisov case. Privacy is essentially a freestanding or a separate matter, and it is those 2 cases, the Bulgarian case and Leander, which are really, as I said in the email, authority for the proposition that where you have retention of personal data in an employment context, and there is no disclosure of that data, and that data is relied upon in refusing the application, Article 8 will be engaged, and the procedural duties under Article 8 will arise. I'm happy to go to the paragraphs of those cases. Equally, I did give them in my email yesterday, and in the interest of being time, I'm very happy to deal with those points by way of reply for the court.
I think that's okay. Yeah, no, that's fine. To deal with it by reply.
Subject to anything else the court wants me to address at this point, I'll wait to.
Thank you very much, Mr. Vaughan.
Thank you.
Sir James.
My Lord, I've heard the very helpful provisional views expressed by the court. There is at least a question, whatever one does procedurally, in terms of rolled up or retaining it or sending it back to the High Court. There is a question about the grounds.
Yes.
And I'm not going to bleat for too long or at all about the way in which the claim has been formulated and reformulated and is now still being formulated on the hoof. But that remains, and if this case is to go forward in any shape or form, I respectfully submit that there needs to be one target rather than a perpetually moving target.
Well, I can entirely endorse that sentiment, and we will make sure whatever directions we give, but we'll ask you, if you will, and your junior, to think about how we achieve that.
Yes, I mean, it rather takes one to the way in which the grounds are formulated. The submissions I was proposing to make on permission sought to group the various and myriad different ways in which the claim was put under at least some logical heading. So
I mean, we look
one can then address them.
I mean, I look at it. I won't speak for my
with fairness at the heart of it.
colleagues. The fairness is at the heart of it.
I respectfully agree, and everything else tends to flow from that.
Everything flows from that, and Article 8
As an adjunct.
is an adjunct, and Regulation 30 is probably an additional interesting adjunct.
Well, that's why I was going to start there, because, as it were, in terms of slithing the branches off the livable tree, I do respectfully submit that there isn't actually a sensible and properly arguable case in relation to the interpretation, which is the way in which it's put,
About Article 8.
of Regulation 30.
Oh, Regulation 30.
Because Regulation 30 started life, as you will have seen, on the basis that it didn't permit, as a matter of interpretation, it did not permit consultation with anyone other than the individual senior judge identified as a statutory consultee. That got abandoned, and it got abandoned for jolly good reasons. And the reasons were, in very brief summary, because there is nothing in the language to support any such interpretation, so the language is against it, nor, we submit, is there any possible or sensible basis for an implication of that restriction in Regulation 30. If that had been intended, given its specificity, it's pretty surprising that it wasn't done expressly. But it would also risk, as the judge rightly pointed out, by the judge I mean not Mrs. Justice Lang but Mr. Justice Swift, who produced a decision on the oral permission hearing, it would render the process, or risk rendering the process of consultation, ineffective. one can add to that point a rhetorical question at least. Why restrict it in this way? What would be the legislative purpose of doing that? It would be entirely counterproductive not to be able to seek views if they would or might shed light on the suitability of a candidate for the important judicial post in question. And it would render, as the judge pointed out, the process arbitrary, because you might know more, less, or nothing about the individual candidate as the statutory consultee, which here Lord Justice Haddon gave. So all of those vices sat in the way of that argument of interpretation, which has now gone.
Do you agree with my sort of first impression, which is that it would be unwise if one were granting permission on fairness, which is the core of this case, which will obviously require a look at the process which the JAC undertakes and its statutory foundation, not also to give permission on Article 8 and Regulation 30, simply because they are the backdrop to that question. And salami slicing is never helpful when one hasn't had the full argument and the full case. Even if fairness is the core, they ought to be allowed to say, and Article 8 has this consequence, and that proportionality leads to this conclusion and all that, which seems to me perfectly sensible in the rough and tumble of the litigation. The reason we took out Article 14, the reason we're inclined to take out Article 14 is that it seems to add absolutely nothing to the Article 8 point.
My Lord, I respectfully agree, and the only reason I'm troubling you for a very short period on Regulation 30 is because I respectfully submit it doesn't, as it were, have that sheen of being associated with the fairness in the same way, because it raises a discrete issue of statutory interpretation, however it's put. And the new way in which it's put is that it permits information gathering only from one or at most two judges or particular types of judge, so the leadership judge. And I respectfully submit that that way of looking at it is equally hopeless. It doesn't impinge on the fairness argument, to which I will come, and if you'll forgive me, I'll make a few submissions on that, in recognising the court's provisional view. But Regulation 30, as an interpretive point, is hopeless, we submit. If you look at that way, which is the only way which is now maintained, the same essential points apply. One, nothing in the language to support it. Two, the more nuanced the assertion about the constraint that is implied into it, the more surprising it is that it isn't dealt with expressly. So if it truly was intended to permit only consultation with one or two or the leadership judge, why doesn't it say that? Three, the same purposive questions. What's the legislative policy that requires that implication? All of the same adventitious elements, all of the same benefits in leaving the extent of information gathering to the good sense and rational judgment of the statutory consultee. There's no inherent or structural risk of cronyism, if that's the suggestion. The senior judge, who is usually appointed as the statutory consultee, has more than sufficient good sense to deal with that, I respectfully submit. And as Mr. Justice Swift rightly pointed out, the JAC itself, when you get to the higher levels of that committee structure, which in this case had Lord Kakar and Lady Justice Carr sitting at the helm, are more than capable of being well alive to those risks. So we respectfully submit that the Reg 30 arguments can and should be sived out. Shall I turn brief? I'm sorry, my Lord.
We haven't yet actually just looked at the language of Regulation 30. I've had some difficulty understanding how the system as it operates at present fits into that language. It may be that it doesn't, and you simply say it's a necessary implication from what does. But if you look at 31B, is what we're concerned with here, the statutory consultee is someone who's held the office for which the selection is to be made, which I think in this case would be a circuit judge, so clearly that's not what's engaged here, or has other relevant experience. So you say that the SPT, or the SPJ, is someone who has relevant experience, because as SPJ he sits at the top of the system under which everyone's engaged.
A bit
So
difficult.
I just wanted to work through.
Yes, a bit difficult to interpret, has other relevant experience, as it were, as excluding a person who sits in a higher judicial office than the one to which the person might be appointed.
I see how you put it.
My Lord isn't suggesting that a Lord Justice of Appeal sitting in that role would be inappropriate or outside the scope of that provision.
I'm not really suggesting anything. I'm just trying to see how it's meant to work. When I first read it, I thought has other experience like a circuit judge, but I see also how you put it. Just leave it there.
Yeah.
So is 32 irrelevant? But because that is the commission itself consulting someone else.
Yes.
So really, what you're saying is that it is implicit in the system under 31B, second limb, other relevant, the person without a relevant experience, though I suppose it would apply also to a former circuit judge, doesn't have only to deploy their own experience or their own knowledge, but can ask anyone else who they think will help it reach a view.
There's nothing
So
surprising.
the whole system of sub-consultation, and this is, again, I'm not being critical, I'm just seeing how it works. The whole system of sub-consultation simply arises by a common sense implication of what the statute must have intended in allowing you to consult with a senior leadership judge such as the...
Yes, and perhaps also, if one looks at the flip side of the same coin, the absence of any prohibition on that. So if there was going to be a prohibition on the statutory consultee talking to other people or exploring a range of views to inform their own consultation, we're not in delegatus non potest delegari. We're not in that sort of situation.
Is that Latin?
I know we're not allowed to use Latin.
No.
You know what I mean? There's no prohibition on that.
Understand it, but
Yes, but my respectful submission. You can either say it's implicit as a common sense view of how this must work,
Yes.
Yeah.
or there isn't a statutory.
no, it's
prohibition
as simple
on
as
it.
that. But
Yeah.
when I first looked at this regulation, I was expecting to see some sort of
Positive permission to
positive
sub-consult.
permission to consult other people. And you say no, but that must be what's intended. How else could it work?
No, because you don't need it, because that Latin principle that I just mentioned wouldn't otherwise apply. So you don't need that. What you're actually needing, therefore, is something which prohibits or tells you can only do that in the sort of ways that are contended against me. That's the Regulation 30 interpretation. Must you read this as precluding any form of consultation other than with one or two people or a particular category of person?
But it sort of has an overlap, doesn't it, with the fairness, the entire fairness of the process. And whilst I, take on board all you've said, if we were to give permission or perhaps order a rolled up hearing, you may say that's the better course. But either way, if there is to be a complete review of this process, how it works, and its lawfulness in every aspect, then not to, and when the appellant has made it very clear that front and centre she sees Regulation 30 as the problem, it would be perhaps unhelpful for that review in an important case simply to exclude it.
Well, my Lord, I would see the force of that if the argument that surrounds unfairness would otherwise preclude the court looking at Regulation 30 as part of the context. And no one is suggesting that. But what is being done here is to elevate, as a separate and freestanding ground of legal challenge, a contention or set of contentions around the meaning and interpretation and effect of this provision.
The real problem is that this case has sort of grown like Topsy, and at different points in time, different emphasis has been laid. That's the real problem. And I think what we need to do today, at the very least, is to make sure that the case is clear before it goes further. And,
My Lord, I respectfully agree, but I do submit that Regulation 30, whatever view one takes about unfairness, must be viewed in its own terms. It doesn't stop the court looking at Reg 30. It doesn't stop the court saying the starting point for the fairness argument is the statutory consultee can sub-consult. Now, what do you do with the product?
You say that the the substantive point they raise about Regulation 30 is bad, and therefore we shouldn't let it go.
Untenable as a point of interpretation.
As a point of interpretation.
Completely separately from unfairness.
Yeah.
Can I just raise one further point before we move on? Para 2 does give an express permission for the not for the appropriate authority to consult other people, but for the Commission itself to consult other people. So you could have a scheme under which you went to the SPJ and said, "What do you think?" And he said, "Well, I need you to allow me to approach leadership judges, or in the case of a DJ, the circuit judge, whether or not a leadership judge with whom that person most regularly works," and then they would be given permission under Regulation 2. Could it be argued that, sorry, under Para 2, could it be argued that was the scheme intended by the regulation?
What, so as to preclude a sub-consultation by the person who is a statutory
Yes.
consultee under one?
Yeah.
My respectful submission is not. It's a separate and discrete power,
Yeah.
which is exercised by the Commission in that way.
We don't know how often it is. It's hard to see circumstances in which it would be necessary.
Yes, I don't know the practice, whether there has been, and if so, in what circumstances, but my submission in principle in answer to
Your submissions were not
it's-
concerned with it
it's
here,
discrete.
and it doesn't shed any useful light on.
Exactly.
Okay, thank you. I
That's
just
how I
wanted to
put
get
it.
to the bottom of that.
And I see it. But that's how I put it, and I say, perhaps most importantly on this one, whatever you do on fairness, this should be treated as a separate point of challenge based on the interpretation of that provision. So he's got to show you that there's an arguable case that he's right on that interpretation. My respectful submission is there's no way of interpreting the relevant provision in the way that would be needed to support a case that it contains an implicit restriction, it's 2 judges at most or only the leadership judge, which assumes your ability to sub-consult, and then, which is the point my lord is putting to me, and then says, and it's only these people. So that's what I say about Regulation 30. My lord, so far as unfairness is concerned, again, as I understand it now, and as it were on the hoof, I thought it was still live, but it doesn't appear to be. We've deleted the allegation that says, or the contention that says it's unfair because the JAC or the SCC, that's the subcommittee, the Selection and Character Committee of the JAC, it's unfair that they are allowed to override, as it's put, a panel. And you remember how this works. This is derived from the idea that the panel produced a C and then the JAC altered it to a D. And that is said to be structurally unfair that they even have the ability to do that. As I understand it, the line has been put through that in my learned friend's exercise in answer to the questions from the court about the relief. So what this really comes down to is whether or not fairness requires that there should be disclosure of and or attempts made to secure that the statutory preconditions to disclosure of the, let's call them the references, but it's the responses by the sub-consultees, that those should be disclosed.
Or the gist of them without possibly identifying, or that some approach should be made to the statutory consultees to say, do you mind if we ask the applicant what they say about this, because it appears to be a fairly, what should we say, contestable
My lord,
situation.
I encompass all of that. It's not been terribly clearly expressed, but yes, it's gist, it's do the thing that you need if you have to go and get consent. And
It's really the question, is there a complete embargo, or should there be a complete embargo? Is it fair that there's a complete embargo in a factual situation, which in this particular case is quite stark?
well, my lord, my answer to that is that the requirement to disclose those confidential consultation responses into the statutory consultee is not arguably a precondition of a fair scheme in this context. We know that fairness is a context-specific question, and we know that as part of that, the court considers all of the safeguards that are involved in the process and then makes a judgment about whether or not a particular ingredient is fair.
But that's not enough for you, is it? I mean, just to say it's not arguably a precondition of fairness to actually disclose the consultation doesn't get you home, because it may be that different situations require different things to achieve fairness. I mean, I take the Dyke point, which I put to Mr. Vaughan. You know, you will be saying, no doubt, as this case progresses, that you open the Dyke just a little and it's impossible to hold back the water. But, and that might be a perfectly right submission in the end, but why is it possible to, by simply taking the extreme position and rebutting it, say that some intermediate position is not required to achieve fairness in a stark factual position?
Well, there's nothing to suggest that the starkness of the factual position in this case, and Mr. Justice Swift, I respectfully submit, was right about the Dyke point. There's nothing to suggest that the starkness of the position in this case, because the person went from a C to a D, provides, as it were, a special feature. Adverse comments as part of that consultation process, feeding into the statutory consultee, are a common and expected feature of the system. There's nothing on the facts of this case that would enable one to say, well, okay, you don't normally have to do it, but this is a special case for these reasons. That doesn't serve any distinguishing feature. But my respectful submission is that there is nothing in the statutory scheme or otherwise that would require, as a matter of fairness, adverse comments to be disclosed. The first point is the Dyke point, but it isn't the only point. We know that there are also other elements of the process that are designed to enable this or these sorts of comments to be tested as part of the process. The applicant for a judicial office can, and regularly does, produce their own direct evidence aimed at specific, nominated, known in advance competencies. So it's for them to advance the evidence. That's an essential part of this feature, of this system. But they can do that, and that's...
But you're not saying that in this case, where she was conscious on her own evidence of the fact that this event had occurred, this unfortunate series of events really had occurred, that she should have put in her own evidence to rebut it, in case in statutory consultation it was mentioned when she, having been prevailed upon to withdraw her complaint, may have hoped it had gone away.
Well, my lord, she could have put in and was able to put in whatever she wished.
Yes, I know, but it's not reasonable to suppose that any applicant for a judicial position is going to try and rebut things that they know are out there, but are certainly not crystallised in any... there wasn't, for example, I mean, it's a different situation if there had been a complaint upheld against her and she was making an application for judicial promotion, knowing that, then of course you'd expect her to say, I was held guilty, I was given a warning or whatever it was, and the reasons were this. But this is a completely different position. This is
well, Lord, it is, but I make the structural point first, which is that applicants can do this, and the second point related to the specific facts of this case are one needs to be very careful. If the suggestion is that there is, as it were, animus, and there's an expectation that there might be animus from people who feed into the statutory consultee, then that's a pretty serious allegation, and would need to be made good. Hasn't been pleaded out.
I mean, that is the allegation, that there might be animus. I mean, not that there is animus, because she doesn't know, but there might be.
Well, if there is, then...
because of what happened in the events which have been clearly outlined.
Right. Well, if that is a genuine concern, then I respectfully don't agree that if an applicant is in that position and worries about that there will be any detriment to them. It's not an awkward thing. They're able to produce the evidence. They can say, I had this concern, these events happened, here's the explanation of it, and so bear that in mind. There's nothing to prevent them from saying that, if that is genuinely a worry for them. And there's no downside to that. I'm so sorry.
No. My apologies. I just have difficulty with you suggesting it's not awkward for them. I would have thought it's very awkward for them. I mean, this is a judge who was accused of bullying. Those allegations were found to be without foundation, and yet it is there in a relatively closed court centre where word got out. When you're putting in your application, you want to do the best you can. I would have thought it's extremely awkward, actually.
Well, my lady, even if it is awkward, maybe that's just that is the, if there is a concern that it's going to affect the process, the question is whether it's so awkward as to be unreasonable to raise it if they want to. And my broader point is that there is the opportunity for that to be done, awkward or not. I mean, these are important things that the Commission has to grapple with ultimately, the panel has to grapple with. And if there are elements that a potential judge...
But this is not black or white, black and white, Sir James, really, is it? I mean, the very fact that there is, a discussion between bench and bar about whether it might be awkward to do this or that indicates that this case needs to be heard properly and resolved and aired in public. I mean, this is a matter of great public concern, the independence of our judiciary, the appointment process by which we achieve the independent, the best merit-based appointment process, we would like to say, I was going to say in the world, but that sounds jingoistic, the very best independent appointments process we can possibly achieve. And, the fact that you can make a bare submission that it's not awkward for a judge to proactively rebut things that might be said by statutory consultation without her later knowing is, which might be questionable. So there needs to be a hearing about it, surely. What is fair?
My submission is that doesn't lead, the one doesn't lead to the other. I don't want to get sucked into this whole thing turning on the debate as to whether or not it's awkward.
No.
They have the capacity to feed into the process.
They do.
That is a strong structural element supporting fairness, is the first submission.
Yes.
The second submission is that there are layers of consideration and process. Mr. Justice Swift was right in his description of the multiple ingredients of the process, the ways in which the panels work, the interview process, and all of that, and then the consideration by the SCC of the Appointments Commission itself. Those layers are themselves a strong supporter of fairness because they enable all aspects to be probed. There's a specific part of that, which is that if there are adverse comments that are produced by the sub-consultees, those can be and are probed at the selection day. And as we've alleged in our summary grounds, that indeed occurred in this case.
But that's rebutted by the judge. She specifically says that at the selection day, nothing directly or indirectly was raised of an adverse nature. It's in her witness statement, Sir James.
My lady, yes, but again, that is a position that she takes, having not seen, for good reason, I submit, the statutory consultation responses. The case that I advance on behalf of the Judicial Appointments Commission is that it's an integral part of this process, that if there are adverse comments in those confidential statutory consultation responses, then there is an opportunity to put them during that process, and that they were also considered as part of her application. So whatever she says in her witness statement, the fact of the matter is that was the process that was followed in this case, and it's an integral part of the process more generally. That should be done. That's one of the purposes of that panel stage. And at all stages of this process, whether it's the panel reacting to adverse comments in the sub-consultation responses, or going through the role play forms that are undertaken, all of those elements of the process, or indeed the final stage of the consideration by the Commission. All of those processes are undertaken by experienced people, including experienced and senior judges, who are very well used to weighing and to putting points, and to putting points in a way that does not breach the thoroughly important confidentiality underpinning that is the statutory consultation process. And that perhaps is the final point to make in relation to the structures that exist here. Not merely are those done by experienced people, not merely are there multiple layers which include the ability to put and the fact of putting adverse comments to the relevant candidates, but there is an inherent issue with providing the detail, or indeed a gist that might give away the detail, of statutory consultation responses. In this world, perhaps a fortiori in this world, as in the broader employment sphere, references and confidential feedback are confidential for good reason. And they're confidential for good reason because they need to be as full and frank as possible. And that is a virtue of the system, is thoroughly emphasised, I respectfully submit, not merely by the case law that we have cited from the broader employment context, cases such as Milner, that we referred to in our skeleton at paragraph 33.2, tab 7 of the authorities, don't invite you to turn it up, but even in the employment context, non-judicial, fairness does not require disclosure of references. A fortiori we submit in the context of appointments to judicial office, where the nature of the appointment, the nature of the role or the office, as one of His Majesty's judges, is of considerable importance. All the more reason for the comments that are made to benefit from the ability to be confidential. And if there was any doubt about that, I respectfully submit it's put to bed by the relevant statutory provisions that you've seen referred to in our summary grounds and that you now have in the supplemental bundle, including the specific provision in the DPA, paragraph 14.1 of Schedule 2, Supplemental Authorities, tab 1, paragraph 14.1, which specifically excludes, in effect, from subject
which
matter.
page is that? I haven't got that immediately in my head, Sir James.
I don't know whether they got electronically numbered, but it's in the first tab. It's the very beginning of the supplemental bundle that I think my learned friend submitted
Para 6.
recently. It starts with para 6, and if you go forward a few pages, or a couple of pages, to paragraph 14, on page 4 at the bottom, 14.1. It's the passage we quoted in paragraph.
Yeah, just show me it in the original.
In the original, it's paragraph 14 of Schedule 2. Do you have that?
Yes.
Subparagraph 1.
The listed GDPR provisions do not apply to personal data processed for the purpose of assessing a person's suitability for judicial office.
Yeah. So that effectively the relevant provisions are those that have subject access request. So under the DPA, you can make a subject access request for information held by a public authority that relates to you, essentially. And what this does is to exclude all information.
Yeah, no, I went through it and I just couldn't find that.
Yes, well, I'm sorry, but that's because it wasn't in there. Well, we had quoted it in our summary grounds, but that's in there. There's also, it may be said, even in the broader employment context, and it's one of the reasons why the Article 14 case doesn't work, but there's also, if you go a couple of pages further on, paragraph 24, I suspect it's a subset, but even in the broader employment context, so there's a specific provision about applying for judicial office. You can't demand anything to do with that, no documents, and then confidential references, a few pages further on, paragraph 24, even in the broader employment context, the subject access request, effectively, the listed provisions, don't apply to personal data consisting of a reference given in confidence for the purpose of education, training or employment. So we respectfully submit that the confidentiality underpinned by the desirability of frankness, particularly in relation to the appointment to a judicial office, is specifically and positively recognised by statute.
Yes, that's the way you put it, and that although clearly the statute, both the statute and the GDPR regs are helpful to your case, but it would be the case even without them, you would say, as a matter of common law or general law.
Exactly so. But recognised, that's why I put it in that way, in the statutory scheme. And that is important because, again, to some extent, it goes back to the questions that the court was asking at the beginning of my learned friend. You know, what do you challenge? Are you challenging the non-provision of information? The answer to that appears to be yes. And then the court alighted on, I think it was paragraph 8 of Mr. Justice Swift's judgment, where he said there's no specific challenge. My learned friend fairly says, well, that's because you haven't seen it, and that's a fair enough response. But what it tends to throw up and to highlight is the idea that is the point that we respectfully submit. There isn't an obligation, and it isn't an obligation created simply because you choose to issue judicial review proceedings. There isn't an obligation, and there's real merit in not disclosing confidential, let's call them references, in our case it's information provided by sub-consultees to the statutory consultee. There is a strong public interest in not doing that, and we've deliberately taken the position in this case, as you will have seen from our summary grounds, that we are not required to do that.
But the more moderate way, which I think is the way Mr. Vaughan is now going, of putting the case, is that all that granted, that important principle would not in every case create an obstacle, because there are two circumstances in which it would be acceptable. One is if the sub-consultee in question consents, which raises the question, should they in certain circumstances be asked to consent?
Yeah, they would have to be.
They would have to be. And secondly, where it is possible, which it will be sometimes, and in other cases won't be, but possible to put the gist of the adverse comment in such a way that the identity of the sub-consultee isn't clear, couldn't practically be identified.
Yeah, my lord, the latter I've already made submissions about, because I respectfully submit that that's inherent in the process anyway. That's part and parcel of what is done on the interview day.
Well, I wonder. I mean,
there's no statute.
You said what you said is as they go through, if they have adverse comment, they always put them.
I'm not sure they always put them. I'm not sure I said it.
Well, they
always put them, but
they will put them if they're going to attach weights to them.
Yeah, they consider them as part of that process. They have the applicant before them. As I understand it, and as we've set out in our summary grounds, there is a process on the selection day, I think it's called. My lords and my lady will be much more familiar with how this actually works.
It is the selection day.
I'm sorry?
It's an entrenched use of language. Selection day.
Yeah, selection day. But at selection day, as I understand it, there's a process involving role play, and then there are views formed about that, and then there's an interview process. And prior to that selection day, again, there's no statutory requirement for this. This is the way it's been set up, and I rely upon the way it's been set up to support fairness. But as I understand it, there is then an interview process, and at that selection day, or before that selection day, those who are organising it and running it will have
yes, I see.
the sub-consultation responses. So that is the opportunity to probe that.
So you really say it comes down to this. If the gist of the adverse comment can be put, and so as to get answers on it,
without revealing the identity.
Without revealing the identity of the consultee, and if it is likely to be material to the decision, it may not be, but if it is, then, although not statutorily, as part of the system of recognised fairness built into the system, it will be put.
It will / can be put, and more. Well, I don't want to feather it.
In order to be fair, it ought to be put if it can be put without disclosing the identity of the constituent.
Well, I'm prepared to accept that, and I would add to that we know that there's a two-tier process. And this is one of the complaints. It went from C to D between the two, as it were. But there would be nothing, I respectfully submit, to preclude the commission, if it got to that stage, thinking, well, maybe we need to interview again. I mean, so if they thought that was appropriate, that wouldn't be excluded as a matter of power.
Well, can we just come back to that for a moment? But conceptually, that may be more messy in principle. You say it really only comes down to consent, because if the substance can be put without disclosure of identity, there may be mistakes in particular cases, but the system is one in which it will be put if it's material to the decision.
And certainly, yes, and certainly will be considered.
Yeah.
So it is consent.
But it wasn't here.
Well, sorry.
But it wasn't here, as far as we know.
Well, I'm not sure one.
It may be contested, but it appears that that's the case of the appellant.
But I'm afraid the appellant is not in a position to aver that, because the appellant can't know that. You can't know whether it was put or not unless you know what was said. But
I see.
well, no, I don't mean that to be casuistic. I mean, it follows from not revealing that part of it.
But am I not right in thinking, I may not have got this quite right, that it emerges from what has already been accepted on behalf of the JAC in the summary grounds of resistance, but the reason why a different decision was made at the SCC was because the first committee, the panel, had not considered the adverse comments, and therefore one might think, it can reasonably be inferred, had not put them, even in a way in which whether or not the appellant recognised they were being put. You could sometimes have a case in which, indeed, if the gisting system is working, the appellant won't always realise what has prompted this particular list of questions, but it may nevertheless happen. But it didn't happen here, because we're told, in your own admissions, that the panels didn't attach importance to this, and therefore, square brackets, didn't ask about it.
No,
have I not?
Yeah, I don't think you have. Quite.
Okay.
I'm sorry. I mean, again, I need to be careful, because what we've pleaded is what we've pleaded. I don't want to step beyond the bounds of that.
No, well, let's look at it. If you say something different is said.
Well, I think the first it's gone, I think, is in 28 and 29 of the summary grounds on page 96 of the bundle. Again, I'm very conscious, if this becomes a great big factual issue, then of course that would be a factor bearing into permission.
Give the numbers again.
28 is page 96.
Yeah, the pages are all out of order.
Well, I'm sorry, it's paragraph 28 and 29 of our summary grounds, paragraphs.
Yes, got those.
Well, we've tried fairly to summarise what we can from the facts there.
Yes, I see. It's not quite, what you say there isn't quite as I put it.
Particularly the first sentence of paragraph 29. May also be not quite as I put it, so it might both be at fault.
They noted that the comments were not fully supportive of the claimant. And we can see specifically, for it follows in the next sentence, it's not spelled out, specifically on the WCO competence. But they said that notwithstanding that, they thought that was sufficiently evidenced. It might be thought to be implicit in that they didn't ask about those.
Yes.
Yes.
Exactly.
Well, I'm not sure I'd accept that implication, but I fully accept that if we get down into those weeds, then we're in the facts. So
Yeah. I think one of the difficulties I have, Sir James, and I say at once, we don't have a full picture of the evidence.
No,
and that's why I'm very concerned about that aspect of it, is that the time to ask was the panel interview. If the candidate wasn't asked, and then the SSC take a different view, which may be an issue of weight. We are still in the position that they haven't asked first instance, and the SEC doesn't have the opportunity unless one comes to what might be an exceptional example, recall.
My lady, I see that. And I'm not sure I can put it any higher. I certainly do not want to be stepping outside the bounds of the careful pleading, because it's been done with some care for
But
obvious
it may have a
reasons.
bearing on whether you wish to put in any evidence if permission were granted.
Well, quite so, but at the moment we're at the prior stage, which
Well, we're not, because we're dealing with this on a rolled-up basis, Sir James. So you need to address the points that I asked Mr. Vaughan about as well.
My Lord, I do. What I meant by we're at the prior stage.
No, I
meant
mean
we're
your
at the
submissions.
prior stage where I'm trying to persuade you not to grant permission.
No,
not very successfully, as it turns out. But you have my points about the structure. You have my points about the way in which it's intended to work. I do not want to go beyond the boundaries of what can properly be inferred from 28 and 29.
We respect that, and we hope you
If that takes you into facts that you regard as important, well, there we are. I recognise that.
we
would be
hope
anywhere.
that you do not think that we're not listening, because we are.
My Lord, of course not.
Yes.
But anyway, that's how we put it effectively.
Yeah.
It's a fair system. It's designed to enable
Yeah,
things to react. If you conclude that there is doubt about whether or not particular aspects of that did actually work in the present context as intended, well, that's a different matter. I can't go beyond the boundaries of the pleading so far as that is concerned.
Yes,
But
that would be a very different kind of case.
it would.
It would be a case where the safeguards in what you say an inherently fair system didn't work for a particular reason.
Exactly so. And that may be something that the court will need to bear in mind, because I maintain the submission that in principle and in structure, the system is fair and is, if one wants to put it this way, capable of operating in a fair manner. It has those various layers. It has the opportunities for evidence to be fed in, for adverse comments to be put in a careful way that doesn't breach confidentiality. It has the layering. It has the judges involved who are well used to.
It does raise a question, which I'm not asking you to comment on now, but just to get the thought out there, that if this is that kind of case, what kind of relief is appropriate, given that competition is over?
Yes, well, the answer to that may raise different issues, because, as we've consistently emphasised to this claimant, it remains open to her at any time in I think their annual processes, but at any time to reapply. So I think the position is there's just been one and she hasn't reapplied, but it remains open to her to do so. And she can put in whatever evidence she wishes, and the system will then operate.
I mean,
So-
this is a comment, Sir James, and you can take it as you find it. We have great experience of these competitions on the bench here, and speaking for myself, I do too. And one should not underestimate the pressures on applicants in these competitions. It's all very well for those who sit above it to say this is nothing, you can reapply, of course, and you'll be fine next time, perhaps. But these competitions are really important to real people who are serving our society, particularly when they're already serving judges. And I just wouldn't want anybody to think that we took this lightly and said, oh, well, if at first you don't succeed, try again. That's not the right approach. These competitions are of tremendous importance to people. They're taken really, really to heart. And we have to get it right if we can. And in a sense, I think that's all part of this analysis. And it's why, for my part, I'm unhappy about just, even if I thought the complaint wouldn't succeed, I'm unhappy if there's just a germ of what needs to be looked at more closely, that it goes out at the permission stage.
Well, my Lord, I
You
very,
see the point?
I do entirely, and I very much hope that nothing I said in answer to my Lord Justice Underhill's question, and particularly representing the client that I do, nothing was intended to.
No, I
detract
know,
from
I
anything.
know.
The question was a
haven't-
pure one about remedy, given that, as I understood it, given that the process has in fact concluded, and given that it's not suggested that she should be recommended for an appointment, she would have to go through another process. That was the only point I
Yes,
was on.
okay.
No
I mean,
disrespect
my
to the
point
process.
is that we live as judges with this process. We invest in its fairness. We invest in its transparency. We invest in it being the best of its kind. And we want it to be like that. We expect it to be like that. We do everything possible to make it like that. And that was why I balked when you said, oh, well, she can apply again. I know you didn't say it like that, but
Well, it was simply a
we have to
remedial,
be
a
jolly
remedial
careful
point.
about that.
I
sort of
understand
thing.
that.
Yeah.
But and also, as I say, I don't think it would be sensible for me to make the submission that even though there are two aspects to this, as has now become very clear, one, is the system in principle capable of delivering fairness and fair? Two, did it operate fairly on the facts of this case? It probably isn't sensible, I respectfully submit, whatever procedural route you choose to take, to split out those two elements, because they're obviously interrelated, however strong you may feel the case is that the thing is structurally fair, whatever happened on the facts of this case. Well, that's what we say. I'm not going to keep banging the drum. It's a permission hearing. Article 8, we respectfully submit there are a series of arguments, including in particular a bunch of case law from Strasbourg, including a case in which someone was dismissed as a president of a court of appeal, in which the Strasbourg court has held that even that was insufficient to engage Article 8, and they are very wary about engaging Article 8 in the employment context. But if you
Partly because he was only a year or two away from retirement anyway. But
well, my lord, yes, quite. But so be it. Nevertheless, he
No,
was
all right,
dismissed from that important.
they are quite fact specific, these cases.
They're very fact specific, but the strong lead from Strasbourg is it's going to be very, very rare before Article 8 is engaged.
Yeah, well,
In an employment appointment process.
yes.
But if you feel that the Article 8 issues are so closely related as to provide an echo, then I'm not going to die in a ditch over that. Article 14, however, at the moment I respectfully agree, I completely fail to understand how that works. Not least because, as you've seen from the provisions that I took you to in the supplemental bundle, that the Article 14 case, I mean, as we all know how the basic structure works, there's got to be a difference of treatment between groups that are analogous on the grounds of a status, even recognising that status means almost anything from being able to stand up onwards. But there's still got to be a difference of treatment which is unjustified between analogous groups. I'm not entirely sure how the analogous groups analysis is intended to work or is even asserted to work.
Yes.
It appears to be between a judicial, a person who's applying for a judicial post on the one hand and a person who's applying for an ordinary employment post on another.
An ordinary employment post in the JAC. I know, but that's how it's put in the status,
Right.
presumably to make it look as analogous as possible. But
in the JAC, it's employment in a private post or in a civil service post, which is the JAC. It doesn't matter, not a non-judicial post. But as we've seen, the distinction between those two for relevant purposes tends pretty much to collapse because the same exclusion, if it's built on the DPA, in effect applies. Under paragraph 14, it's a goner because there's a specific statutory provision that says it's a goner in relation to all documents related to that process. And if anyone's going to have a challenge of that position, they would need to bring it against the minister, and it would have to be a Section 4 HRA claim. And we'd say, no doubt, I'd be instructed to turn up and tell you there was a broad margin of appreciation in setting these things up, and you couldn't possibly challenge that as a statutory provision. But more importantly, for the discrimination argument, you get exactly the same rule in the private employment equivalent context on references in paragraph 24. So we respectfully submit for all sorts of
even more fundamentally still, quite apart from the statute, the same basic practice would apply. Someone gives you a confidential reference. It's very hard to believe that the JAC, outside the judicial context, say JAC as an employer, would say, well, I know this was in confidence, but I think you should see it.
Well, I respectfully agree. At one point, I thought the argument was going to be, well, there's a bit of a difference because under paragraph 14, there's an absolute preclusion. And if it's in the private employment context, it's a bit more balancing. But I'm not sure that works in the light of paragraph 24. And even if it did, to the extent there were those marginal differences, that we would respectfully submit that it's perfectly obviously justified as a distinction because the former is to do with appointments to the post of a judge, and there are specific and mighty public interests associated with getting that process right.
But I'm not even aware, this case wouldn't come up very often, in any common law context of a court saying, well, it's all a matter of discretion whether you can break a confidence. I mean, at some deep theoretical level it might be so, but it's hard to see a circumstance in which you would say to be being unfair in not disclosing to someone for an applicant for employment adverse information you have heard, though of course I'm sure the law would say that you should do your best to put the substance of the concern to the person in a way which didn't breach the confidence, which you say is what ought to happen here.
That's a different point. Exactly. So it's the disclosure of...
But that's the point, no difference in treatment.
No difference in treatment is the easy point, and if you needed to get to justification, it's perfectly obvious anyway. But that's what we say about Article. So Article 14 can be stripped out, I respectfully submit, which would leave, if you're so minded, probably the structural and the specific unfairness cases with whatever Article 8 points were actually thought to add to anything on that. And that leaves me, I think, only with the question that the court helpfully asked about process and whether you retain it or you don't. I mean, I rather suspect that the content of the discussion we've been having today suggests that it's going to be difficult, if not impossible, certainly on our side, not to want to explore and put in clarificatory evidence if that's appropriate.
Yes, but at what level? I mean, we're not talking, are we, about documentation, historical...
No. We're not talking about a vast ream of evidence. But what I mean, I would certainly not preclude the possibility of us wanting to put in some evidence about how the process works, what the elements of it look like, what happened in this
But
specific
the least
case.
we would have, you wouldn't ever just rely on your summary grounds of resistance.
No.
There would be a witness statement saying the things that appear there with such elaboration or support as you judge necessary.
It would be proper to have that in evidential form, I respectfully submit.
I can't imagine you wouldn't.
No, and so the question then really is whether or not it's better, recognising that there probably will be, almost certainly will be evidence. It won't be gigantic reams of evidence, but it will be evidence. Is this one of those cases where the Court of Appeal wishes to keep it to itself? I mean, I suspect the submission probably ought to be that this is a case, because it will have some evidential content, in which it might be thought the Court of Appeal, if it is to consider this, might benefit from a first instance judgment exploring all the issues before it comes up here. But I'm in no better position to make that submission than you are to judge it, if you see what I mean.
It's just the timing, really. It's
Yes.
gone on a long time.
It has.
And
It has.
it's you know, I said it was stressful to keep on applying for judicial appointments. It's also stressful to keep on having hearings of a judicial review. And if we could do it in a confined timescale, I mean, do you have an idea, bearing in mind what is in your head as to the evidence that's likely to be filed on behalf of the JAC as to how long the hearing would be?
I would suspect it's going to be no more than a day or possibly a day and a half.
Yeah.
And it certainly wouldn't be longer than a
2
day.
days.
Well,
but it won't be longer than 2 days.
I was initially thinking one with the half day being added just in case there's a spillover, but it's up to you if you're...
Yeah.
I mean,
Well, I think this is a case personally that would benefit from some exposition. So I wouldn't want to confine counsel on either side. I'd want to really chew it over. So I think I would allow 2 days personally. But I agree, we might not need it.
well, in which case, my lord, I'm in your hands. I certainly don't have strong instructions to push unreservedly.
No. Do you have an idea of timing as to how long you?
Well, my lord, the standard directions would be, if it went back, there would be standard directions. We had a draft order on the basis that it did go back, and there are then standard directions, which I think start with 35 days for evidence, and there are then various sequence steps. And I suspect this isn't a case where the Court of Appeal, however important it regards the issues as being, would be saying, we need to rush this on.
No.
So those...
The total period, I've never totted it up, but from the point of view of the normal procedural steps, it could be ready to be heard
in the Michaelmas term.
In the Michaelmas term.
It could.
Whether we could accommodate it is a separate question.
Yeah, it could. With certainly the the procedural steps that would need to be gone through could lead to that sort of listing if the court had time.
Okay. Good.
Well, not only
Thank
those,
you.
those are my submissions.
Thank you very much. Thank you. Mr. Vaughan.
Well, Lord, my lady, I was going to just address very quickly Regulation 30 of Article 8, but I'm happy to be stopped if that isn't necessary.
Do we? Yep, yep.
Thank you. Our submission below and here is that the interpretation of Regulation 30 depends in part on what Article 8 requires of it. And so, as I say, that was the case put below, and that's the way that it's been put in the skeleton argument here. And one of the questions that Article 8 requires the court to consider is whether there are adequate safeguards against abuse arising from the withholding of material, which may have been decisive of the application. Now, if I may, I want to illustrate that by reference to Leander, because the analysis about safeguards has to look at every aspect of the system, whether legal, policy, and so if I could take the court to that, which is in the supplementary bundle, second tab at page 8. You can see from the head note in the preliminary paragraph that this was an individual who had been refused employment as a museum technician with the Naval Museum in Sweden on account of secret information, which it was said made him a security risk. And he said that the vetting had involved an attack on his reputation and should have had an opportunity to defend himself. And we can see from 1A of the head note that it was uncontested that an interference with his rights under Article 8.1 had occurred through information being held in a secret police register about him, combined with the refusal to allow the applicant an opportunity to refute the information. Now, the court went on to hold that the interference was justified because of the presence of adequate safeguards. And there's no indication in the ruling as to what the information was on the database that rendered him unappointable. If we can go to paragraph 48 on page 25 of the judgment. The conclusion about engagement is stated at 48, essentially what the head note says.
Yeah.
And then in going on to examine in accordance with the law, the court looked at the accessibility and foreseeability of the domestic law between 50 and 57. And then from 58, the court looks at the necessary in a democratic society and proportionality issue by looking at the various safeguards that the Swedish government were relying on. So at paragraph 61 we can see that the guarantee, he was saying that the guarantees available didn't allow him to challenge the correctness of the information about him. And then paragraph 62 includes the Swedish government's submissions about 12 different safeguards which provided adequate protection when taken together. Now, I'm not going to go through all of them, but I'm showing this to the court to make the point that the whole system that is in place and the meaning of Regulation 30 and the underlying primary legislation will be relevant to whether there is, taken as a whole, sufficient safeguards in the system to guard against abuse. The particular nature of those safeguards in that case are not relevant, but you can see, directly relevant, but you can see from paragraph 67 that the court ultimately concluded that those safeguards were sufficient to guard against abuse, and particularly the national security context was important in reaching that conclusion. that essentially secrecy prevailed over Leander's interests. Now, if we look at what the court would need to do in determining the Article 8 issue in this case, I'm taking the court to this to make the point that Article 8 and regulation...
It's a simple point. I mean, your submission is that the whole system will be relevant as to whether, taken as a whole, there were sufficient safeguards to guard against abuse, and that will involve a look at the interpretation of Regulation 30, not just the point that Sir James made, namely that it's clear that you can consult others because it doesn't say you can't. But I mean, I take the point that Regulation 30 is relevant to what you're going to argue on fairness.
My lord, yes, that is a point.
Good.
And I think in the context of, since we were looking at national security, it is relevant perhaps to observe that in the national security context here, a person challenging a public law decision in the High Court would have potentially more disclosure of adverse matters held against them by a public law decision by virtue of the process in that act. And of course, I'm not saying that there should be exactly the same provision in this context, but it has to be the case that a close look needs to be given to the procedural devices available to ensure that fairness is secured. Just very briefly in response to my learned friend's point about Denisov. In Denisov, there was no withholding of data about that judge. He was told that he wasn't good at managing his court. He knew the basis for the decision, and the issue was how the consequential effects of that decision on him engaged his Article 8 rights. Reduction in salary, he relied on embarrassment, etc. We are not in that kind of situation, for the reasons I've given. Very briefly on Article 14 and 8, very simply in relation to no difference, I hear the points my own friend and the court makes about that. My submission about difference in treatment is simply that the exclusions in relation to judicial appointments are wider than those applicable to regular employment contexts. In a normal employment context, the exclusion is simply confidential references. Whereas in this context, all information which is processed for the purposes of judicial appointments is covered by the exclusion. And by way of example, as to just testing as to that difference, it's not clear that comments made to the JAC about an incident or event involving Judge Thomas some years ago would constitute a reference. It's a much broader concept, particularly when read with the approach to confidentiality in section 139. In relation to justification, my learned friend says, well, that's an easy one for the JAC, but I would say that the proportionality considerations are similar to those under Article 8, and so the difference in treatment, the court accepts argument there is one, is going to be looked at in terms of justification in a similar way to that of Article 8.
That's like cuts both ways. What does putting it in terms of Article 14, which is not the way it was put first time, add? Doesn't really add anything, does it?
It doesn't take the appellant further than Article 8. I accept that. In terms of just lastly in relation to relief, it's been said a number of times by the respondent that it's open for Judge Thomas to reapply. The thing that was held against her could be held against her forever. And that is why she wants the information, or the gist of that information, so she can seek to address that in the future, should she see fit to do so. So the reapplication point is not an answer to her request for the relief by way of the information itself. I think, as I've already said, retaining the matter in this court and standard directions, as you may have in the High Court, we have no objection to, and I'm happy, obviously, to send to the court on the other side an amended statement of remedies, so that we can be clear, respondent can be clear about what's being responded to. Is there any other matter the court wishes me to address?
Well, I need to know what you want to do about this sort of ad hoc amendment to your relief. And if you were to get permission, do you need or want time to sort of make one final attempt within the bounds of what has been put forward so far to clarify and distill your case?
My lord, yes, and I think in the light of our discussions, that would be of assistance to Respondent.
How long would you like for that if we were being indulgent?
Would 14 days be acceptable? I'm happy to do it within whatever time frame this court
Well, that's
requires.
what you want. I mean, it's likely the court will direct you to agree that with Sir James, but I wanted to know that it wasn't 3 months. Okay.
If it were at all possible to do it after, if there's any leeway to do it within 1 month, that would be.
No, there isn't.
Let's hope that you would do it. We'd have it ready for us today.
I was hoping today or 7 days, but
I can only apologise for that.
we're going to just take a moment to tell you how we're going to deal with this. So we'll rise for 5 minutes, but don't go anywhere because it may not be very long.
Court rise at table. Please be aware that
Sorry, Sue.
Yeah, I do.
So do we have a position on how long we can have?
You're not going to get more than 7 days. We've been told that. No matter what we say. Right?
Yeah.
court rise at table.
What we're going to do is rise now, and we're going to sit again at 2:30 when we'll give a short oral, maybe more than one, but short oral judgment, at least one. If anybody doesn't wish to be here because your commitments don't allow it, feel free to send somebody else. in the shape and form of a junior, if that's more convenient. So we'll sit again at 2:30.
My Lord, my learned junior has very helpfully produced a draft order in the event that permission is granted, which may be of assistance to the court. Could
Could it
I
be sent electronically?
it can be sent electronically as well, but I was just going to hand it up and then tell you the changes that
Oh, okay.
might be proposed if you grant permission.
Would you like to see?
Well, not normally, but since it's Sir James, I will look at this paper.
Thanks very much.
It's too small for me to read.
No, well, we can send it to you electronically, but I was just going to suggest that we don't need paragraph 1, so that can be struck through, I think. Paragraph numbered 4 ought to be, if you decide Court of Appeal, just replace Court of Appeal for High Court.
Mm-hmm.
Paragraph 5, if you thought 2 days would be 2 days, and it would then be, perhaps we replace not before a Deputy High Court judge with to be listed if possible in the Michaelmas term, or something.
Yeah.
And then between 6 and 7,
Well,
You
why
prob-
don't we, yeah.
we probably need something on the claimant's pleading consequent upon, if you do limit the grounds, whatever limitation there is. So, but there's going to need to be a provision for them to put in something. And I think I respectfully submit it would be helpful to have, once you've decided that, if you do decide it's going to be limited to certain grounds, the permission, I respectfully submit it would be helpful to have a proper pleading limited to those grounds and not stretching outside it, with the relief that is actually claimed in relation to those. And that could be done within, say, 7 days, and then the rest of the timetable follows.
It's easy enough to amend the relief. Obviously, Mr. Bourne has some thoughts about that already. But you're suggesting...
I'm suggesting we get a pleading, which we're actually going to have to respond to and deal with, but that is limited to the grounds, if the court does decide to limit the grounds to those grounds that are actually granted, he's actually been granted permission on. Because otherwise you risk everything becoming just an amorphous muddle again. And then he's stuck with that. That's the pleading. That's the case we then have to meet.
Yes.
Yeah.
Can I say that I entirely endorse all of that? All I would say is if it's possible in relation to the amended pleading to have a month, because I've got, but I'll be led by the court. But
Right, well, what
I've got limited availability.
we're not going to have a long debate about 7, 14 days or a month. What we are going to do, I think, is not to make this order. We're going to direct the parties, in the event that leave is granted, to agree an order, but we will, in the judgment, make clear the ambit of the case that we're expecting to see in any revised grounds. So we will resume at 2:30.
Well, would you forgive me if I'm not here this afternoon?
Of course.
Thank you.
All rise